The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. My name is Hunter Wiles, and I'm a paralegal at Wiles Parker. Thank you for joining us today for our monthly Webinar Wednesday series, which is presented by Wiles Parker and sponsored by the Texas Association for Home Care and Hospice. Today's topic is preventing the revocation of your Medicare billing privileges. A little over a year ago, the number of reasons that CMS can cite when revoking a Medicare provider's billing privileges greatly expanded. Since that time, CMS contractors have been aggressively revoking providers on a near constant basis. How can your agency avoid being revoked? How should your agency respond if your billing privileges are terminated or revoked? What impact can these actions have on a home health or hospice agency? In this webinar, attorneys Jennifer Papapanagiotou and Ashley Morgan will discuss the current revocation actions being pursued by the government, how your agency can reduce its risk of being subjected to such an adverse action. This webinar is scheduled for 60 minutes with a Q&A session to follow. Jennifer is a partner at Wiles Parker with over 20 years of experience in healthcare legal and compliance issues. Jennifer focuses her practice on transactional, corporate, and regulatory matters for healthcare providers and suppliers, including but not limited to home health and hospice agencies. Her work focuses on the types of issues healthcare providers deal with every day, including operational compliance issues, drafting contracts, including medical directorships, employment agreements, management contracts, etc., buying and selling healthcare provider businesses, and more. Ashley is senior counsel at Wiles Parker. She represents healthcare providers across the country in connection with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board complaints, revocation, exclusion, and termination issues. Ashley has worked with an assortment of providers, including dentists, home health companies, hospice agencies, primary care, and specialty physicians. Ms. Morgan is a certified professional coder, certified medical reimbursement specialist, and a certified medical compliance officer. With that being said, I will pass it on to today's presenters.
Thank you, Hunter, and good afternoon. Thank you, everyone, for joining us today. Hunter, we can go ahead and go on to the next slide. Just a brief disclaimer, this information that we're providing today is just informational in nature and does not constitute legal advice. You should always contact your own legal counsel if you have a legal concern. Okay, next slide, Hunter. So today we're going to talk about revocations, reasons that you can be revoked, some changes to the enrollment and revocation rules that happened in 2019, and we're now seeing start to play out by the agency and them taking action and using their authority with those new rules and regulations. So we're just going to give you some information about the new reporting obligations, talk about new enrollment denial reasons, new revocation reasons, how these changes affect Medicaid and CHIP, and then some compliance challenges that these new regulations present to providers. And then we'll wrap up with a brief discussion about COVID-19 waivers as they are related to enrollment. Okay, next slide. So just some brief background about the revocation and enrollment environment over the last several years. I guess more than several, since we're starting in 2006, I should say. But in 2006, enrollment requirements were codified. There was an obligation for providers to actively update their enrollment records. And then in 2011, there were some screening categories that were introduced for providers that were considered high, medium, low risk. And there were moratoria that were permitted on enrollments for certain providers. I know that impacted some areas for home healthcare providers. And then in 2015, we saw that the denial reasons for enrollment were expanded to include uncollected debts. Subsequently, after that, in 2016, there was a proposed expansion of reporting requirements for providers and for revocation and denial reasons. And these are what we're going to be mostly focused on today, these proposed expansion that finally went into effect in 2019, in November of 2019, we anxiously awaited after that the proposed rulemaking was issued in 2016 for years, and advised clients that these things were coming, and we just continued to wait. And it took quite a bit of time for them to actually finalize those regulations, but they are now in effect as of November 4th, 2019. And we do have a little note here that there was a GAO report, a Government Accountability Office report that was issued. CMS did not provide sufficient notice to that they're required to provide notice to Congress about new rules, like the ones that were issued on enrollments and revocations, and that notice was not appropriate. So the new rules actually could not take effect earlier than March 17th, 2020. And we did have actually some cases that were being argued during that time period based on the new rules, and we had some success with arguments about their ability to utilize the new regs due to their insufficient notice. So that was an issue, but now that we are past March 17th, 2020, those new regulations are in effect, and the notice was provided to Congress. Next slide. So CMS proposed these new rules, and the reasoning they provided in the rulemaking was that the new enrollment rules and the new revocation rules could result in an additional 2,600 additional revocations a year that would save the government possibly up to $4.16 billion over 10 years. And that the new re-enrollment and reapplication bar could save up to $1.79 billion over 10 years, with an estimate that it would save $20.7 billion over 5 years. And that specifically is due to a rule that we're going to talk about quite a bit today. And it's a new affiliation disclosure and revocation authority that essentially prohibits people who may have an uncollected debt or other things that the government considers risky associated with them from entering into the program or enrolling as a Medicare provider under a different entity. Those things are becoming disclosable now if you owe a debt or were previously affiliated with a company that owes a debt to the government. They're trying to prevent people from re-enrolling with Medicare and continuing to be a Medicare provider when debts are hanging out there. So that's where they're getting these proposed savings from keeping those people who they consider, more or less having like a straw man agency out there from creating new entities. And next slide, Hunter. Okay, and now Jennifer's going to talk some about the new reporting obligations.
Thank you, Ashley, and I guess happy lunchtime, everybody. Thanks for joining us today. The new regulations included a number of new reporting obligations, but I would caveat all of that with the fact that CMS has decided to take a phased-in approach to how they are going to implement these regulations. So as of today, there actually is no affirmative obligation to report new under these affiliation regulations. There are some other areas where some changes were made about reporting that we'll cover later, but those have to do with updating existing enrollment records, not with the new affiliation disclosure regulations. So the new rule, as Ashley mentioned, arguably went into effect November 2019, although GAO really did delay it until March of 2020. I don't want to belabor that. It's in effect now. The phased-in approach has essentially what CMS says in the final rulemaking is that they can use these regulations to take action under their new authority, but they are not currently requiring providers to report affiliations unless, quote, CMS requests that you do so. CMS has sent a follow-up an MLN Matters article that discusses this in a little more detail. It came out in March of 2021, and they've said in these various pronouncements that they've put out there that they're going to promulgate new enrollment forms and that they will not require any kind of affirmative reporting on behalf of providers until those new enrollment forms are final. And the latest update we got was just last month, and they actually put a publication out there that said it's going to be at least another year before they propose new enrollment forms. And it's been very clear since the final rule went out that those are going to go through notice of comment and rulemaking. So we will have an opportunity to review those forms, and the stakeholder communities will have an opportunity to provide feedback on them through formal comment. And I will anxiously await them, because the enrollment forms are notoriously complicated. And as someone who helps providers through the enrollment process or reporting changes on a very regular basis, I have lots of opinions about them. So it'll be really interesting to see what they end up putting out there. But suffice it to say, it's going to be at least another year. And I would not be surprised if it's longer than that. CMS has had quite a bit on its plate with COVID. And I will say that they've spent the last year and a half basically reorganizing and reissuing their provider enrollment guidance in the program integrity manual. That's the CMS. They're the manuals that CMS uses to sort of give sub-regulatory guidance on all the regulations. The program integrity manual, and specifically it used to be chapter 15. It's now been reorganized in a new chapter 10. It is almost 800 pages long, and it incorporates all of the new regulatory provisions that went into effect at the end of 2019, beginning of 2020. So they're preparing, and they really spent the last year working on that and COVID, and not on new enrollment forms. So we'll see what happens with that. But so everybody is prepared when the day does come that we're going to have to make these reports, we want you to be familiar with what the reporting obligations include. And the newest and latest and greatest requirements will be to report affiliations and disclosable events. And I want to be clear that this is right now, you only have to give this information if you are requested to do so directly by CMS or your MAC. And if you are requested, or when the time comes that we have to do this, you will report any owner, and that's a direct or indirect owner, that's reportable on your enrollment, or managing employee, and there's a definition of that as well, with an affiliation. And affiliation is a defined term. We're going to talk about that on a subsequent slide here. With any other Medicare, Medicaid, or CHIP provider or supplier in the past 5 years, if that other provider has had a disclosable event. So there are a lot of terms to unpack here. There's definitions of owner, there's definitions of managing employee, and there's definitions of affiliation and disclosable event. So we're going to talk about those here in more detail. There's a standard for how much information or how hard you have to look for that information. And essentially what CMS has said in the final rule is that you must report if an owner or managing employee knew or should reasonably have known that their former affiliation had a disclosable event. It is very unclear at this point what knew or should reasonably have known actually is going to require as far as due diligence when a provider has to make these disclosures. CMS said in the final rule that they would give us additional guidance on that in the manuals, and they have not, at least not at this point. So I would suspect we're going to get additional guidance sometime before the forms are promulgated, and we're anxiously awaiting to know, is it going to be enough just to send to search public resources? Is it going to be enough just to send a letter requesting information? It's pretty clear it isn't going to be sufficient to just check public resources. And that's sort of come informally, both through reading sort of between the lines in the final rulemaking and also in discussions at various informal events with CMS. But no one's really sure, is there going to be some sort of safe harbor for, I did enough research to identify affiliations with disclosable events? We haven't seen that yet. The bad news, of course, is that if you don't report something you're supposed to, it can result in denial or revocation of enrollment. That's the hammer they're going to hold over everybody's head. But CMS isn't going to do anything with this information that is reported until they do what they call an assessment of whether or not that disclosable event poses an undue risk to the Medicare program. And if they determine in their discretion that it does pose an undue risk, then the provider can be revoked or denied. I want to go to the next slide because I really think we need to dig into what some of these terms mean. So the first important term that we need to become familiar with is what is an affiliation, because that's going to sort of, those are the things you're going to have to research. So you're going to look at your list of who owners and managing employees for your current entity that is making the report. So if you're a home health agency and you have 2 owners and 1 managing employee, you're going to have those 2 owners and that 1 managing employee sit down and make a list of every other Medicare enrolled or Medicaid enrolled or CHIP enrolled entity that they have had one of these listed relationships with in the last 5 years. Have they been a 5% or greater direct or indirect owner of another healthcare organization that was enrolled? Have they, did they hold a general or limited partnership interest in another organization? Did they have operational or managerial control over another operation or organization? Were they an officer or director of another organization? And if they're a physician or non-physician practitioner, did they have a reassignment relationship with another organization? That's going to be a really challenging one for some organizations, especially, physician entities that have physician ownership, but also have a lot of physician involvement. And it could get really messy for our physician clients. I'm not sure it's going to be as big of an issue for home health and hospice, but it can in certain circumstances. Let's go to the next slide. So if you identify you've got 2 owners and 1 managing employee that meet one of those definitions, and they had one of those defined relationships with another healthcare entity. So let's say those 2 owners, one of them was also an owner of another healthcare company, whatever that might be, a DME company. We'll just hypothesize. You then have to go do research to find out. So that one owner owned a DME company within the last 5 years. He was, say, a 50% owner of another company. You then have to find out from him, or potentially by contacting that other company, whether that other company has had a disclosable event. Yes, you heard me correctly. You're going to have to find out if another provider that you really have no relationship with has had a disclosable event. And they're supposed to just tell you. So this is where this becomes very, very challenging. So what are disclosable events? There's a pretty specific list, and it includes uncollected debts. So you're, as a reporting provider, you're supposed to contact these other companies and ask them if they have uncollected debts. Yes, that is exactly what this regulation says. Do they have current uncollected debts to Medicare, Medicaid, or CHIP, regardless of the amount, whether it's being repaid or whether it's being appealed? That's I mean, can you imagine you got a phone call from somebody asking you this question, and you're an owner of a home health company, said, well, Joe Smith works for us now, or he's an owner of our company now, and we'd like to know if you have any uncollected debts. The implementation of this regulation and it's mind-boggling to me how this is actually going to play out in real life. It's going to be very, very challenging. The next disclosable event is any payment suspension, regardless of when the payment suspension occurred or was imposed. And it's really important to understand that the 3 bottom ones here, payment suspension, exclusion, and Medicare, Medicaid, or CHIP enrollment, denial, revocation, or termination, they have no time limit on them. So if that affiliated entity had a disclosable event, and the disclosable event would include any payment suspension, any exclusion, or any enrollment, denial, revocation, or termination at any time, it would be something you would have to report. So I'm going to sum all this up at the end and try to put all these pieces together for you. But suffice it to say that the scope of what has to be disclosed requires a really, really robust institutional knowledge about the history of the provider organization. And you might imagine that provider organizations change ownership over time. Things that happened 20 years ago may or may not be something current ownership is 100% aware of necessarily. This gets real dicey, especially with organizations that have been around a long time. So I know some of the things we have been thinking about as we digest how to advise clients about these regulations are, there aren't great publicly available resources for providers to go research this information. There's no database I can go to and find out if a provider has ever been suspended, or publicly available database to find out if there is an uncollected debt. I can check for exclusion, so that's good, assuming it's been appropriately reported in the places where it's supposed to be. But I can't go and find out if someone's been denied, revoked, or terminated from Medicare, Medicaid, or CHIP either. So I'm not entirely clear what CMS is going to expect. And this sort of plays into that. You have to report things or should reasonably know. And I'm hoping CMS may give us some better guidance than we have now, which is virtually nothing, and also perhaps give us some new tools to help do this research. Otherwise, we're going to be relying on other organizations to sort of gratuitously share this information. So more to come on that. Let's go to the next slide. All right. Uncollected debt I touched on earlier. It is a defined term under the regulations, and it includes Medicare, Medicaid, or CHIP overpayments for which CMS, the state, has sent notice of the debt to the affiliated provider or supplier. It doesn't include routine denial letters or routine adjustments, but it does include civil money penalties imposed under CMS regs and assessments imposed under Medicare regs. These are the ones where you've received a demand for repayment. Generally, these are the sort of routine audit demand letters we see, and it is not the individual sort of we denied a claim, or we reviewed one claim and we're recouping the money. These are not your something more than just the day-to-day adjustments that you see. Again, we may get some more guidance on this or specific places where this information, the contractors are going to research this information, but we haven't received that yet. Lots and lots and lots of folks are really worried about this because, as you might imagine, there are lots of people out there fighting audits. And these are reportable regardless of the status of the debt, whether it's under appeal or not. So it is a little disconcerting that at some point in the future, we're going to have to report this information. And again, remember, when you're reporting it, this is information about one of your current owners or managing employees. And this is information about another entity that they were involved with at some point in the last 5 years. So this isn't information about your entity. So a little challenging here. Let's go to the next option, the next slide. So the last important term we want to look at is undue risk. So once CMS has this information, what are they going to do with it? The evaluation of undue risk, there are some factors that they included in the final reg. And I've listed those here: duration of the affiliation, whether it's current, or if the affiliation has been terminated, the degree or extent of affiliation. So they are going to consider if your owner or managing employee was like a 1% owner, or I wouldn't even say that, probably a 5% owner, 6% owner, or were they 100% owner of the affiliated entity that had some kind of disclosable event. That's going to enter into their analysis. They're going to look at why did you terminate the affiliation if it has been terminated? And then they're going to look at the type of action that's been disclosed, when it occurred, and if it's an uncollected debt, the amount, whether it's being repaid, and to whom the debt is owed. And then, of course, the catch-all, anything else CMS deems is relevant. What this ultimately means is that every assessment of undue risk is going to be a discretionary decision by CMS. And I'd like to say that there's a transparent process that you get to be involved in, but there's not. They are going to take the information that you report it's going to go into a black box. The MAC's going to gather the information, and it's very clear that the MACs are not going to be able to make decisions about denials or revocations on their own under these regs. They are going to have to ask CMS to look at the file and make a decision. And then CMS is going to come back with that decision. And when they deny or revoke you under these regs, you're going to get a very brief letter that says, we're denying your enrollment or we're revoking your enrollment based on the affiliation authority. And maybe you'll get a sentence that will tell you why. In our experience, and Ashley and I deal with revocation actions weekly on various reasons, the information they give you can be less than useful. And it often requires us to go back to CMS and ask for more information. And we often don't get a lot of specifics until an appeal is filed and a decision is rendered. And then we'll get a lot more detail. So it is going to be really interesting to see how CMS decides to use this discretion. They have not given any real substantive guidance on this other than what's in the regulation itself. I asked the question of a contact at CMS informally about how they're going to do these kinds of assessments, and he literally spit back the reg to me directly. There was no other information. So let's go to the next slide. All right, Ashley, I think you were going to cover the new denial reasons.
Yes, thank you, Jennifer. So on the slide here, you'll see we've listed the reasons that an enrollment application can be denied. And you'll see that before they issued the new regulation, there were quite a few reasons they could already deny an enrollment application. And they've added 3 new reasons, and they've changed one of the existing reasons that they can deny an enrollment application, which was the payment suspension. And the new regulation added the 3 new ones, which were revoked under a different name, an affiliation that poses an undue risk, or a different program termination or suspension. So we're going to review the changed and new enrollment denial reasons in more depth with you, so we can go on to the next slide. Okay, so the first one I want to address is the current payment suspension. So just, brief overview. So we're talking just about enrollment. So this is if you're applying as a new Medicare provider, a new entity, you're submitting an 855 or you're in PAYCO submitting a new enrollment application. So they can, something that you have to report in that enrollment application is current Medicare suspension. So previously, this only applied to Medicare suspensions of owners, physicians, and non-physician practitioners. However, the new regulation expanded to include Medicaid suspensions, and it also changed to include all provider and supplier types and managing employees. So you see we have in red on the screen the specific language that was added, that they may apply the provision to the provider or supplier under any of the provider or supplier's owning or managing employees, or the organization's current or former names, numerical identifiers, or business entities, or to any of its existing enrollments. So they just broadened that language to catch more, I guess I would say, affiliations in that category. So it's not just your current Medicare suspensions of your owners, physicians, or non-physician practitioners. You're going to now need to also disclose any Medicaid suspensions, and then if you have any managing employees that have any current payment suspensions, if they own another entity that has some sort of payment suspension, then that needs to be disclosed on your enrollment application. But I will say that here it is just still applying to current payment suspension. So if you were on a payment suspension and then that suspension was terminated before you submitted the application, then that's no longer a current payment suspension. So not something that would need to be submitted in your enrollment application. It's just the current payment suspension.
Let me just clarify. It's not necessarily that it's not disclosable. That's kind of a separate question about whether you report something on an enrollment application. This is reasons they can deny the application. So yes, there are lots of things that we report on enrollment applications that don't necessarily prevent you from being enrolled. what they've said here, what's interesting here is if you have a currently enrolled entity that you're an owner or managing employee of, and you apply to enroll a new entity and your current one is under a payment suspension, they're going to deny the new application.
Mm-hmm.
That's pretty clear.
Yep.
So reportable or not reportable, there's a list of final adverse actions that you have to report on every enrollment application, and you have to keep that list current. We'll talk a little bit about that under the failure to report revocation reason later on, but just wanted to be clear. It may be reportable, but might not necessarily result in a denial of enrollment, unless, as we've said, it's a current payment suspension, in which case it likely will.
Yes. Yes. Thank you, Jennifer, for clarifying that. Okay, Hunter, I think we can move on to the next slide. Okay, the next reason why CMS could deny an enrollment application would be if there is a revocation that is under a different name, numerical identifier, or business identity, and there is a re-enrollment bar in place that has not expired. So if you were a home health company and that home health company was revoked and they put in place a 3-year re-enrollment bar, and then you went to go, open a new home health care agency, and CMS, through its due diligence, saw that your name was affiliated with that previously revoked entity, then they could deny, and likely would deny, the enrollment application for the new company, simply based on the fact that you are associated with both of those companies, with the new company that's trying to enroll and with that previously enrolled company. Now, they have provided some factors that they're going to consider when they're determining and trying to investigate the commonality between a revoked entity and a new entity that's trying to enroll, and those are listed here. They're obviously going to look at the owning and managing employees, and they're saying that they're going to be looking at that whether, regardless of whether they were disclosed on the form AP5 or not. They do have their own databases and things that they can review, so they're going to be investigating that. They're going to be looking at the geographic location. Is it, at the same physical address as a previously revoked entity? They're going to look at the provider supplier type. For example, are you just a home health agency and you're reopening another home health agency, or is it a different type of company? They'll take a look at business structure. And then, of course, any other evidence that they have or are able to obtain that indicates that the parties are similar. That's their infamous catch-all. And the reason that they have stated that they're including this as a new denial reason is we have some language here on the screen that they've indicated and identified instances where a provider or supplier has had its Medicare enrollment revoked, but tries to evade the revocation and re-enrollment bar by opening a new provider supplier organization to effectively replace the revoked entity. And there's also language here from the OIG that they've essentially identified that providers are operating as fronts, where they're having family members or friends or other individuals pose as owners or managers of another entity, but it's really that same individual who is running the revoked entity who's actually operating the business and profiting from the business. So that's the kind of action and actors that they're trying to keep out of the program through this new denial reason and through this new authority to deny enrollment applications by doing this investigative work about the individuals underlying those new enrollment applications that are coming in. And just additionally, we have here, this does not require a showing of undue risk. So I know Jennifer previously, when she was going through some of the definitions, undue risk was one of those things. So here, CMS does not have to show that there is an undue risk to the program. They can just simply identify that here's actor A in this revoked entity, and here's actor B or actor A again in this new entity that's trying to enroll, and they can just deny it based on simply that. They don't have to show that there's a risk to the program and meet that criteria. Okay, let's go on to the next slide. Okay,
I'm going to need to back up a little bit. I think we skipped forward a few slides.
Yeah, we're on slide 14.
Go forward, back a couple more there.
Right. There we go. Affiliation that poses an undue risk. So
My
this
apologies
is another reason. That's okay. So this is another reason that your enrollment application could be denied if CMS, when they're reviewing the enrollment application, they note that one of the reported affiliations, not Jennifer said you're not reporting affiliations yet. That's not going to be, at least for another year, that you're going to be asked to report that on your 855s because they have to run those new enrollment applications through notice and comment. But we just want to make you aware that this is coming. They will be able to deny an enrollment application based on the affiliations that are disclosed that they determine pose an undue risk as they go through that analysis that Jennifer previously outlined. And just as a brief reminder, some things that they're likely would consider to be a risk would be, an uncollected debt, payment suspensions, exclusions, and other program terminations such as Medicare, Medicaid, or CHIP, terminations, revocations, etc. Those are, if you have any owners or managing employees that have any of those types of events related to them, then the agency could determine that just simply because of that affiliation of the company, that affiliation with that person, that managing employee or owner, that the provider does have does pose an undue risk of fraud, waste, or abuse to the program, and then they can deny your enrollment application based on that. So it's really going to be really important as these new reporting obligations and regulations come into effect, and you're reporting these things on your enrollment applications, that you are asking questions of the people that are going to be involved in your company, so you can make sure that you're not going to get an enrollment application denied due to something that one of your owners or managing employees, may not have told you about at the outset. So it's going to be very important to be conducting your due diligence with the individuals involved in your entity. And the last new enrollment denial reason that we have here is other program termination or suspension. So if the provider or supplier is currently terminated or suspended or under a re-enrollment bar or something like that from a state Medicaid program or another federal healthcare program like CHIP, or if the license is currently revoked or suspended in a state other than where they're currently operating, that could be another reason that the enrollment application is denied. So for example, this is more for, especially the licensing, that's more for physicians. But if you have a state Medicaid termination, then, and you're trying to apply to Medicare, that can be a reason that they're going to deny that enrollment application. They previously would only deny for a license revocation or suspension if it was in the same state as well. So that's for, again, for providers. Now they're looking at all states, not just the same state. And they have said that they will consider the reason for the termination or suspension, whether there is more than one action, and then of course any other information that they deem relevant. So they do say that they'll do an analysis here, but like Jennifer said, a lot of times when these things are getting denied, if you get notice that your enrollment application is being denied, you're just going to get a letter saying it's been denied based on this, and you're not going to get a lot of other substantive information. So you're not going to understand really the information underlying that analysis until you go through that first appeals process, likely, just because the letters that we typically see them issue are pretty generic. Okay, we can go to the next slide. Okay, and something new that was also released with the new regulations is a reapplication bar. Previously, if you applied to enroll and they denied your enrollment application, they would just deny the enrollment application, you would have appeal rights. If you let those appeal rights expire, you could go on and apply again. Under the new regulation, there is a reapplication bar, and CMS is permitted to prohibit a prospective provider or supplier from trying to enroll in Medicare for up to 3 years if the enrollment application is denied. But they can only do this if they determine that the provider or supplier submitted false or misleading information on or with or omitted from the form on its application in order to gain enrollment in the Medicare program. So that means if you submit a enrollment application either on the 855 via mail or through PACOS, and you fail to report something, for example, you fail to report an adverse action, and they determine that they believe that that was false or misleading information, and they can say, we are denying your enrollment application, and you also cannot try to enroll again for 3 years. I will say that they did not, say that there was an intent to deceive that was required. I mean, it'll be interesting to see how they interpret this. I personally have not seen them impose a reapplication bar yet. But generally, we see that CMS typically says that if it's incorrect or if it's not there, that's false. Because there's not typically an intent to deceive that's required. So if you have a prior adverse action that's not reported, that wasn't reportable, then that would likely be interpreted as false, and therefore would give them the authority, or they could say that they have the authority under this regulation to then apply that reapplication bar. So it's really critical that if you are applying for enrollment in the Medicare program, that you are making sure that you have fully disclosed all of the required information before you submit that, because now there is a risk that if you did fail to provide information, that enrollment application will not only be denied, that you'll be prohibited from re-enrolling again for several years. So that's just something that it's really important to keep in mind, because you'll really have to rely on that appeals process as opposed to just applying again a couple months later after those appeal rights expire. Okay, I think we can go on to the next slide, and Jennifer is going to talk to us about the new revocation reasons.
Yes, thank you. So we have 2 revocation reasons that were modified by the new regs: the failure to report revocation reason and the Medicaid termination reason. For home health and hospice, if you asked me 2 years ago what the most common revocation reasons that we saw were, they would be number 4, 5, and 10. So on-site false and misleading information, you left something off the application you were supposed to have told them, and it was material to their decision. On-site review, those are your site visits. If you failed site visit because you relocated and you didn't tell CMS about it, they would revoke you, or if they couldn't find you for whatever reason, or they came to visit you and your office was closed during normal work hours. Those were a big proportion of the home health and hospice revocations we handled. And number 10, which was failure to provide documentation. Not as common as the other 2 for sure, but we did see those from time to time. We will expect the new revocation authorities to serve as a basis for a lot more revocations going forward. And let's go to the next slide, and I can, there are 5 new revocation reasons. Really only the first 4 are terribly relevant to home health and hospice, but they are a big 4. So the new revocation reasons that I think are going to be of most importance to home health and hospice are going to be debts that are referred to the U.S. Treasury, revocations under a different name, identifier, or business identity, affiliation that poses an undue risk, and billing from a non-compliant location. And let's dig into those. I'm going to cover the modified reasons fairly briefly, and then we'll talk about the new ones. Let's go to the next slide. Failure to report. So this is an existing revocation reason that was modified by the 2019 reg. Previously, CMS had the authority to revoke a provider if it failed to report a change in practice location or a final adverse action within 30 days. It was very, it happened that people would be revoked under this, but it generally was in conjunction with some other revocation reason. So the failure to report a change in practice location would be coupled with a failed site visit, and people would be revoked, and both reasons would be reported on the revocation letter. The new regulation has greatly expanded the failure to report, and it essentially gives CMS the power to revoke if any data on your enrollment application, any in your enrollment record, anything you see in PACOS or anything that goes on an 855 form, if you fail to report any change in that data, they now have the authority to revoke you. That's a huge expansion of their authority. And I talk to providers every single day that say, oh, well, that correspondence address is out of date, or I need to update that, or minor things that you and I wouldn't consider to be, substantive enough to get you revoked, can now serve as a basis. And I will tell you, in the many, many years that Ashley and I have been handling revocations, CMS is extremely strict with their rules. So if they revoke you and there is a factual basis for that revocation, regardless of what the underlying reason is for why it happened, if the factual basis exists, they will win their case. So it's really, really, really critical that people are not just keeping their, making changes to their enrollment record when really big things happen, like you move locations or there's a change of ownership. I think everybody needs to be implementing a routine process to review their enrollment record in PAYCOS, if not monthly, at least quarterly. And much like you do exclusion screening on a regular basis, you're now going to need to be reviewing your enrollment record very routinely so that you're keeping it absolutely 100% up to date at all times. Okay, enough said about that. Medicaid termination is another modified revocation reason. Previously, you could only be revoked from Medicare if Medicaid revoked you. They have now expanded out to any federal healthcare program termination or revocation. So if you are removed from CHIP, if you're kicked out of federal workers' comp, a TRICARE, any of those will result in a reciprocal revocation from Medicare. I will say that this requires CMS to wait until your appeal rights are exhausted with regard to that other termination or revocation. But I also note that it's applied to the provider or supplier under any of its current or former names, numerical identifiers, or business identities. So they've, again, kind of greatly expanded what they can look at, and we don't have a lot of guidance and haven't seen any terminations under this authority yet. So we're going to keep our eyes peeled for some of these and see how they actually get implemented. The guidance that's been put out there is not real substantive yet. So just something to keep in mind. Let's go to the next slide. Okay, the new revocation reasons, and I said there are 4 of them that are of most interest to us. I'm going to touch on 4. If the debt is referred to the Department of Treasury and it is appropriately referred, then you can be revoked. And there's a list of factors that CMS will consider that include why you haven't repaid the debt, whether you've attempted to repay the debt, have you responded in any way to CMS's request for payment, do you have a history of final adverse actions or payment suspensions? They want to know the amount of the debt, and then, of course, to catch all anything else they think is relevant. Interestingly enough, in the final reg, CMS actually says, well, we only intend to revoke if it's an appropriate referral. Well, Ashley and I see inappropriate referrals all the time. The max will refer debts to Treasury that are absolutely 100% in the appeals process. And it's an automated process, so there's this referral process to Treasury. So it's not even something that a person is consciously doing necessarily. It is something that computer systems monitor, and they'll kick stuff over to Treasury that doesn't, because for whatever reason, that system hasn't acknowledged yet that an appeal was timely filed. So you, as the provider, you have to monitor when you get those notice of intent to refer letters. If you ever get one, it's really important that you immediately address it. If it's something you have filed an appeal, you need to immediately respond to that notice of intent to refer. I suggest, of course, you engage counsel to help you with that, to make sure it gets done. And it's not difficult to get those notices of intent to refer pulled back. It's not even terribly difficult to get a debt that's been referred pulled back if you have a pending appeal. So it's something, again, keep these on your radar. So if you get a notice of intent to refer, or you get an actual notice from Treasury about a debt, that you immediately contact counsel to help you navigate that, because it can get you revoked. Let's go to the next slide. All right. Revoked under a different name, numerical identifier, or business entity. This is very similar to the denial reason. They're looking to keep people out who have some association with an entity that was previously revoked. So they're saying now, if you own multiple businesses, you're an owner who has multiple businesses, and one of them gets revoked, they can attack the others. And this is a huge concern for people who own multiple home health agencies, multiple hospice companies. They're trying to stop people from continuing to participate in the Medicare program if they are affiliated or related to an entity that ran into some problem that got them revoked. CMS does look at the degree of commonality between the organizations. So they're going to, that same list of factors that Ashley went over in the denial reason, it's present under this reg as well. So they'll look at the owning and managing employees, they'll look at the location, they'll look at the provider or supplier type, the business structure, and any other evidence indicating that two parties are similar, or that the provider or supplier was created to circumvent the revocation or re-enrollment bar. They're actively trying to prevent straw owners from owning businesses that are really being run by people who were affiliated with entities that were revoked. So again, it's very similar to the denial reason. You know, what I find, however, is that lots of people own multiple businesses. One may get into trouble for reasons that, you know, it just does. And the first question I get is, how do I protect the other entity? And it's a very complicated analysis, and there are so many factors that go into that, and the kind of guidance that we might give. That all I can say is, if this happens to you, call your healthcare counsel, because it's important that you deal with it proactively, or as proactively as you can. And again, as Ashley said, this doesn't require showing of undue risk. So CMS does exercise discretion, but it doesn't have to decide that there's an undue risk to the program in order to decide to revoke. So let's go to the next slide. Of course, affiliations that pose an undue risk, we already went through the new affiliation reporting requirements. This is what they do with the information once they have it. If you report an affiliation that one of your owners or managing employees has an affiliation with another entity that had a disclosable event, they are then going to do their undue risk assessment and decide whether they should revoke your entity. So congratulations, you complied with the reporting requirements. Now they want to revoke you. Again, this does require an assessment of undue risk. It's the same criteria that Ashley went through under the denial of enrollment provision. And the one thing I would point out, and I think Ashley mentioned this earlier, is that CMS is not going to wait to use this provision until their enrollment forms are updated. They can take action right now today based on their own data, things they have in their databases currently that tie organizations together through ownership. So they can run a report and say, Joe Smith, who owns 50% of this provider, also owns 25% of this other provider. They certainly have the databases and access to that information to run those reports. So I would expect, we've only seen one revocation so far based on an affiliation. I think it could have been done under a couple of different authorities, but they did it under affiliation. And I think we will start to see more of these now that COVID is, and I don't want to be too, optimistic. COVID is waning, but with vaccination rollout and whatnot, CMS is signaling informally, at least, that they're kind of switching their focus. They're still very focused on COVID, but they're also ramping up their integrity operations to look at other things. And we're starting to see that both formally and informally from CMS. Let's go to the next slide. So the last one I'm going to cover, and we're probably going to skip the next slide because it's not terribly relevant to home health and hospice, is billing from a non-compliant location. Let's go back one slide, please. So CMS can revoke a provider or supplier's Medicare enrollment or enrollments, plural, even if all the practice locations associated with particular enrollment comply with Medicare enrollment requirements, if the provider or supplier billed for services performed at or items furnished from a location that it knew or should have known did not comply with Medicare enrollment requirements. And then there's a list of factors that they will consider before they revoke. And those include the reason for the location's non-compliance, the number of additional locations involved, whether there's a history of final adverse actions or Medicare or Medicaid suspensions, the degree of risk the location's continuance poses to the Medicare Trust Fund, the length of time that the non-compliant location was non-compliant, the amount billed from that location, and any other evidence it deems relevant. I will say in the final rule that this seemed very focused on DME. It was not uncommon in the past for DME providers to set up straw locations in multiple jurisdictions because the reimbursement in one particular jurisdiction might be more favorable than it was in another jurisdiction. But they had to have an office location in each state in order to get a provider number in that state. And they'd set up these locations, but they wouldn't necessarily actually provide DME supplies out of that location. They might put a person there, but there was no inventory, or they, bare minimum. And it was very clear that the provider was actually servicing whatever client base it had from another location. And CMS is trying to stop that. I will say, however, that I do enough work with home health and hospice, and I've done, a ton of enrollment work for for home health and hospice, that it is challenging when you're adding locations and kind of navigating through that process, both with state licensing and with Medicare. It can take a very, very long time to get a new location added to your enrollment, especially hospice. And there's guidance under the hospice regs specifically that you absolutely have to have 100% approval from CMS before you render billable services out of a new location that's added to your existing parent entity location. Lots and lots of people either were unaware of that, or they don't 100% meet that standard, and so it arguably could present a risk of revocation under this rule. I've never seen it happen. Generally what happens is this comes up when surveyors come in. They'll say, what do you mean you move locations? Or what do you mean you open a new, well, it's on my license. Okay, but what's the status of you having it added to your Medicare record? Well, I've submitted the documentation and we're still waiting, and those generally in the past, I found CMS Survey and Cert to be pretty patient, and they'd let that process play out, and they wouldn't refer it to anybody else to do anything else. Now, the regulatory authority certainly exists that if you start rendering services at a location that is not active in your enrollment record yet, arguably, and it hasn't been entirely through that enrollment process and received final approval, arguably they could revoke the whole entity and all of its enrolled locations. Again, I haven't seen that happen. That is I think CMS is more focused on DME, but it is a theoretical risk we have to be aware of and at least tell you about. So let's go to the next slide. I know we're running out of time. We're going to skip that slide. I don't think it's terribly relevant to you guys. So there have been modifications to the re-enrollment bar. It used to be a max of 3 years. It's now a max of 10. All I can say to you is we're seeing a whole lot more 10-year revocations. Those are largely happening. Most of the revocations over the last year, I will be honest with you, have been related to the telemedicine DME cases, Operation Brace Yourself. And those generally, the revocations are of physicians, and they tend to be for failing to respond to a documentation request. They go to the physicians, they'll ask for records. The physician can't get the records from whatever telemedicine company you work for because they've closed up shop. Either they've been, raided by the FBI, or they just kind of disappeared into the night. And when the physicians can't respond, they get revoked. And it used to be they got revoked for a year, because I went back and rechecked the guidance, and back in 2018, the manual said if you fail to respond to a documentation request, you'd be revoked for a year. They are now revoking for 10 years if you fail to respond to a documentation request. So they are definitely using these new guidelines, this new regulatory authority. And that's all I'm going to say about it at this point, other than they have also given themselves the ability to lengthen and extend re-enrollment bars if certain facts exist. So if you try to circumvent a re-enrollment bar, they can add more years to your current one. And if you're revoked twice, your bar can be as long as 20 years. So I'm going to skip to the next one. And Ashley, I think you were going to take over, and I probably did one of your slides, but
that's okay.
Please, by all means.
No worries. We are running low on time. Just a quick note about the application to Medicaid and CHIP is that Medicaid and CHIP can now also you have these increased disclosure requirements on their applications as well. States can elect to require all new or revalidating providers to make these kind of affiliation disclosures. So just be aware that you may see similarities in your state Medicaid or CHIP enrollment applications as well, similar to these new regulations for Medicare. Okay, we can go to the next slide. So they, as Jennifer stated earlier, we've seen that CMS has been working to update.
Oop, I think we lost Ashley. Ashley, chime back
Yeah,
in.
yeah.
Oh, are you there?
Can't hear me? Hold on.
Yeah, we can hear you now.
Can you hear me now?
Yes, we
Hello?
can.
Ashley?
Yep, we
Hey,
can
there
hear
you
you.
are.
Can you all hear me?
Yeah, I would just start
Yes.
over with the slide. You were disconnected for about 5-10 seconds. So
Can you hear me?
yes, we can.
Yes, we can hear you.
Okay, I switched to my computer audio. I'm not sure what's going on with my phone, but that's fine. I was just saying that as Jennifer said before, CMS has updated the program integrity manual. They're starting to incorporate some of these new regulations into their manual. They've moved it to Chapter 10. We have a link here on the screen for you if you want to peruse that 800-page document. Interestingly, the manual does say that the MACs can identify revocations, but they can't necessarily implement them without CMS approval. So CMS is going to be making the calls on when they're revoking providers based on these new revocation reasons. And they did, as Jennifer was talking about the re-enrollment bars, there used to be a lot of specific guidance in there regarding the re-enrollment bars that should be applied based on different denial reasons. But now the manual says that the re-enrollment bar should be 1 year for non-compliance, which they can interpret to be up to 10 years, because if it's a records request, and they can say each record that you failed to provide is 1 year of non-compliance. Also 1 year for hardship denials, application fee non-payment, and initial reserve operating funds. The rest seem to be up to CMS's discretion, which can be up to that 10-year bar. So it's a significant change, because there used to be very specific guidance to the contractors on how long of a re-enrollment bar to impose based on the different revocation reasons. Next slide. Just some compliance challenges a major one is going to be providers who are large and have multiple provider numbers. You need to develop a way to track all of those numbers, your owners, your managing employees, and identify any affiliations that might be problematic. As we stated, this isn't something that's reportable yet. It is a revocation risk, but we know the reporting obligation is also coming, and you don't want to be at risk of revocation ever. So you need to identify those affiliations. That's obviously not going to be a very simple task, since there's no way to actually search that information. You're going to really need to rely on your owners and managing employees to provide that information, and when you ask them for it, you're going to need to develop some due diligence process to identify that information, and regularly follow up on that. And we're still waiting on guidance from CMS on this and how far you're going to need to go, but it's something that you certainly should be aware of. Keep an eye, like Jennifer said, on those referrals from Treasury. That happens all the time, and make sure if you get a notice that a debt's being referred, that you reach out to counsel or reach out to the MAC yourself to make sure you're getting that debt called back. Overlapping re-enrollment bars and look-back periods. If you have managing employees, they could be revoked, and that could in fact affect you, and it could be a different period, so that's something you need to be aware of. Next slide, Hunter. You need to just think about how this is going to affect your hiring practices. I've already talked about the reporting obligations for affiliations, but you need to think about how it's going to affect your hiring practices, because you're going to need to start asking about these affiliations and working that into your considerations and documenting in your files that you've asked these certain questions to show that you did your due diligence and that you're following up regularly with your owners and managing employees about those affiliations. We recommend that you do some sort of mandatory review of your enrollment information every 90 days, including your addresses, to make sure you have updated your address properly with Paycos, to make sure you're receiving correspondence. At least we recommend doing that every 90 days to make sure you are compliant. And then Jennifer's going to briefly run over the COVID-19 enrollment waivers with us. Do you want to go to the next slide, Hunter?
Yeah, I'm not going to belabor this because I think most people are familiar with this, and I won't cover the physician and non-physician information. That's probably not all that relevant to you guys, but I did want to note that some of the enrollment waivers that were put into place have actually been removed. And for example, site visits had been put on hold when COVID was originally a problem. That ended July 6, 2020. CMS has resumed all site visits. These are the drive-by visits where they're just confirming that your location is open during posted hours. These can happen at any time, and you may not know that they happen. So it's very, very important. If you had implemented some kind of reduced service at your practice location, I have some clients that were actually doing everything remotely or via telemedicine. That's not going to be sufficient. You need to have your location staffed and have someone on site and available to keep the lights on and answer phones, because they are doing site visits again. I will say the level of activity is not super high, but it is happening. DME accreditation and reaccreditation have been waived. It's not necessarily relevant to this audience, but they have removed that waiver as of last July as well. They are still waiving application fees, criminal background checks, and revalidation. So revalidation is not resumed yet. You may or may not show up on the revalidation database, but they aren't sending out requests for revalidation. And if you've missed a date, they aren't going to deactivate you because they have not resumed revalidation activity. That doesn't mean that you can't do it if you want to, if you come up and your date comes up, but you are not required to right now. There will be a catch-up process once COVID, the public health emergency ends, and I suspect, we'll see them resume their normal schedule of revalidation whenever that is, whenever the public health emergency ends. Let's go to the next slide. If you want to keep tabs on all the COVID emergency waivers and provider enrollment FAQs, I've given you some links. I did update those, make sure they're current. They are. There hasn't been a lot of activity on the provider enrollment FAQ since last July. Things are pretty static, and I'll leave you with that. Go to the last page. You've got our contact information. I'm happy to hang around and answer a question if anybody has one. You can use the chat screen and let us know if there's anything we can help you with. You're more than welcome to email Ashley or me or call the office if you have a specific question you want us to clarify. We're happy to do that offline. Ashley, thank you so much for joining us for lunch.
Mm-hmm.
And thank you guys for spending your lunch hour with us. And Hunter, any wrap up?
I got just one question. Unfortunately, it doesn't have a timestamp, but it says so none of this would apply to the owner's personal finance status with the IRS. And I'm trying to think what that might be. Actually,
now,
like
it should not. These are uncollected debts that specifically have to do with federal healthcare programs. So I don't believe it would have that personal liabilities to the IRS would have any relevance.
Yep, and yeah, that is the only question. And the slides will be going out to all attendees shortly today. So you will also have access to that as well.
All right.
And that is all. Thank you so much for joining us. Thank you. Bye-bye.